Hi guys, welcome back to our YouTube channel. In our last video, we learned about the essential elements of contract. Now, contract according to section 2H of the Indian Contract Act 1872 is an agreement enforceable by law. What we have learned in our last video can be summed up by a line in section 10 which says a contract is an agreement done for some consideration between two parties who are competent to contract with their free consent for an lawful object. Now let us learn about the requirements of an offer. For an offer, there needs to be a proposal to do something or to abstain from doing something. There needs to be an offerer, the person who initiates the offer, and the offeree, the person to whom the offer has been extended. Let us understand this better with the help of an example. Say a painter offers a couple to paint their house for 1500 rupees. Here, the painter is the offerer, the couple is the offeree, and the job of painting the house for 1500 rupees is the offer. To create a valid offer, the offerer must have an intention to form a legal binding. And for the very same purpose, there is the test of a reasonable person. The law is concerned with the appearance of the so-called offerer. So, if you are joking and a reasonable person interpreted it to be a serious offer, then it is said that you have made an offer. But if you are serious and a reasonable person interpreted it to be a joke, then no offer has been said to be made. The test of a reasonable person is an objective test which is used by judge and jurors. The test of reasonable person also examines the facts and circumstances of the matter in light of relevant circumstances. For example, a mother crying for help and offering 2000 rupees to the person who saves her drowning son. Now, this is an offer made in zest or in terror conditions. This cannot be changed into a contract by giving a proper acceptance. Sometimes one party may state tentative terms in order to lure the other party into making an offer. Say, Tanmay says to Mahesh that I'll give you 400 rupees if you sell your laptop to me today. Are you agreeing to my deal? Or Pete says to the class that I am willing to sell my car for 3000 rupees. Is anyone interested? This is not an offer to sell. Social invitations are not intended to create legal obligation. For example, Harry and William decide to go to Megan's house for dinner. Now this is not a contract and not legally binded. So in case either of them decides to cancel their date, she can get offended but cannot sue. The second condition for a valid offer is that the terms of the offer must be complete and clear. It must have all the essential information necessary for the contract. This helps the court to determine the legal binding of the contract, the legal obligation of the contract. Say for example, you are trying to buy a plot. The plot area, allotted parking, water facilities, electricity connections are all the essential informations that you must know before buying that plot. The essential information may depend on the type of transaction. Some offers have implied terms. In a particular contract, some conditions are implied by common law or business laws. For example, when you try to buy a gold item, the price of the item today and the price of the item tomorrow might differ because it is implied that the price is taken out according to the rate of gold on that particular day. Now let us talk about advertisements. Advertisements is newspapers, magazines, radios are not usually treated as offers. The courts treat them as invitation to the customers to make an offer. Say for example, a person who has advertised a TV set in the newspaper, it is implied that he is not going to be able to serve it to the thousands of people who reply to the offer. The condition here is that it is valid only till the stocks last. But an advertisement may become a valid offer if it states the offeree to perform a certain act in order to claim an offer. For example, there is an advertisement that says 13-inch TV is available for 10,000 rupees only to the first 10 customers who walk into the store on a Saturday at 7 p.m. The third condition for a valid offer is that the offer must be communicated to the offeree. A person who is not an intended offeree cannot accept an offer. The second condition is that you cannot accept an offer you know nothing about. For example, there is a general or public reward for saving a child. The person who has never seen or heard of that offer cannot claim that offer. The landmark judgment for this is Lalwan versus Gauri Datta, where the person who saved the child did not know modification or revocation is not valid until it is communicated to the offeree. The offerer may specify while making an offer by when and how the offer must be accepted. When an offer does not come with a specification as to by when the offer needs to be accepted, it is generally given that it is valid for a reasonable amount of time. Now, the reasonable amount of time depends on the goods on which the offer is placed. For example, selling a box of strawberries does not take longer, but when it comes to selling a truck full of strawberries, the time might differ. But it is advisable to mention as to how long the offer stands valid and by how and when the offer must be accepted. An offer ends when the offeree clearly rejects your offer. There is also a provision of counter offer. A counter offer is when the offeree does not outright reject the offerer's offer but suggests a certain modification or suggests changes or renegotiates the terms of the offer. Now it is on the offerer whether to accept or reject the counter offer. Lastly, an offer ends when either the offerer or offeree dies or goes insane. That's all for today's video. We will learn about acceptance in our next video. Stay tuned.